Here's everything you need to know about trademarks in 5 minutes. First off, can I even apply? Thankfully, the qualifications to apply for a trademark are low. If you use your trademark commercially, that is, if you're using your trademark to advertise, promote, and sell your goods or services, you meet the basic requirements. Depending on your industry, this could look like a branded website, storefront signage, or product packaging. If you aren't using your trademark yet, you can file an intent to use application, which defers that proof requirement. So the barrier for entry is very low. Should I apply? Like any business investment, a trademark application is a financial commitment, but it costs less than, say, hiring an employee or buying a company vehicle. The rights can last forever, and it will pay dividends for your brand growth. This is especially true if you're interested in domain name and social media handle capture, have an e-commerce business, or want to future-proof your brick-and-mortar business for geographical expansion. Okay, so where and how do I apply? First, you should do some due diligence, either on your own or with the help of an attorney. Check if there are prior applicants or registrants with the same or similar names in your industry at uspto.gov. This is called a conflict search and can identify problems before you apply, which can save you time and money. When you're ready, visit teas.uspto.gov to access the application form. You'll need to provide some information and evidence and make a few selections. Be careful, your application must be complete, accurate, and comply with USPTO guidelines, or you risk refusal. You'll need to do the following. Provide trademark owner information, including a business address, no PO boxes or virtual addresses. Select the class or classes of goods and services that you sell. Disclaim generic wording in your trademark, like company or service, for example. Sign an affidavit of consent if the trademark references a living individual. And finally, provide proof of commercial trademark use. What should I expect from the exam after applying? Each exam takes 12 to 18 months on average, and you'll be assigned a trademark examiner who is essentially the judge of your application. They'll analyze the information you provide through several phases, including fact-checking your application information, examining your proof of commercial trademark use, comparing your mark to the rest of the USPTO database for potential conflicts, what's called likelihood of confusion, publishing your trademark in the official gazette, which opens the door for opposition, where other trademark owners can challenge your application, and finally, if all goes well, issuing your digital registration certificate. These rights will last for 5 years and can be renewed at 5 and 10-year intervals for as long as you're in business. Knowing all of this, should I file myself or work with an attorney? Well, there's a distinction between filing and handling the exam. The filing itself can take about 15 minutes if you're prepared. The 12 to 18 month examination is where legal inquiries, conflicts, and mistakes are revealed. You can file yourself, but you run the risk of making mistakes that cause delays or outright refusal. And these problems only become apparent during the exam process, sometimes months down the line. So please, if you choose to file on your own, make sure you learn enough about trademark law to approach it confidently. Should I hire an attorney or pay a filing company? If you choose to hire help, always choose an attorney. Trademark filing companies are not licensed in trademark law. They offer cheap filing but no ongoing support for the extensive exam process, or they will upcharge you to connect you with an attorney if an issue pops up. It's always best to cut out the middleman and work with an attorney directly. Plus, trademark law is a specialty area of law. In the same way that you wouldn't want an unlicensed accountant handling your money, you don't want an unlicensed company in charge of your brand's trademark success. Okay, I need some help filing. How should I choose a trademark attorney? Well, there are a few things that you should look for. The first is a good track record. Your trademark attorney should have plenty of prior experience and extensive positive reviews from past clients. Daniel Ross & Associates has served clients across the US since 2016 and has hundreds of 5-star reviews averaging 4.9 stars. You should also look for accessible lines of communication. If you have questions, concerns, or changes in your business, you must have easy access to your attorney to efficiently handle your trademark. DRNA is a boutique trademark law firm, which means we're powerful but personal. Each of my clients works with me directly from beginning to end. And here's a non-negotiable: transparent pricing structure. No one likes surprise bills, and the easiest way to avoid that is with a flat fee, full service pricing. The flat fee means that you pay one upfront price with no hourly fees. Full service means that there are no upcharges for issues or inquiries that might happen during your trademark exam. If you're not getting both, you're not getting the best value for your money. Do you have follow-up questions? Are you considering legal help to secure your trademark? Reach out to us below and let's talk. And thank you for visiting DanielRossLawFirm.com.